Greetings. My name is Brian Brannon, and I am Chair-elect of the Federal Bar Association's ADR section, and I serve on the Federal Bar Association's Diversity and Inclusion Committee. It is my privilege today to be joined by the Honorable Louise LaMothe, U.S. Magistrate Judge for Central District of California based in Santa Barbara. Judge LaMothe is joining me for the Centennial celebration of the Federal Bar Association's 19th Amendment celebration, a woman's right to vote. Judge LaMothe has had a long and storied career in both ADR and at the federal bench level. She's based in Santa Barbara. She's a fellow of the College of Commercial Arbitrators and the former chair of the American Bar Association section of litigation. She's also an arbitrator with an active ADR practice with the American Arbitration Association. Judge LaMothe, thank you so much for being here today.
Thank you very much, Brian. It's my pleasure. So when Brian asked me to talk about my path to the bench, I thought this one will be very unorthodox. And I almost never got here. You know, before I was appointed, I had really rather given up my dreams of becoming a judge and thought that I would satisfy myself by working as an arbitrator and also working as a mediator, which I have enjoyed so much over the years. But I thought I'd step back a little bit and talk about my experiences with federal judges before my appointment to the bench, just to give a little bit of a flavor as to what life was like when I started practicing law. So the very first federal judge who made a tremendous impression on me was Judge Prentice Marshall. And Pren was a federal district judge in Illinois in the mid-1970s. And he became my first mentor. He was the team leader at the first session of the National Institute for Trial Advocacy that was held at the University of Colorado in Boulder for 4 weeks in the summer of 1972. And he ran a section, I think there were 4 sections altogether. He ran one of them. And boy, was I lucky to be in that section. This was an intensive experience of what we call learning by doing. We watched the greatest trial lawyers and judges and law professors, and then we tried to develop our own skills as advocates, not necessarily copying them, but developing our own style. And I learned so much being critiqued in my stand-up performances and watching others. But one of the things that bothered me was that there were almost no other women who were coming in as students. We were all just new lawyers, and there were no women on the faculty at all. So in my review after the course was over, I mentioned that. And I said, you know, it just bothered me that we had no role models who were women, no women judges, no women law professors, and no women advocates. So I got a letter back from Pren a couple of months later, and he said, I took your comments to heart, and the Institute, which by then had adopted the name NITA, the National Institute for Trial Advocacy, has found some money for assistant team leaders for the session we're going to do next summer. And I wonder if you would be mine. So I went, whoa, that was amazing. And it launched me. It launched me because I didn't get just one go round at the National Institute for Trial Advocacy. That was for me a lifelong connection. I taught all the time in the summers. I'd take part of my vacation and go back to Boulder and teach for a week or 2. And everybody always volunteered. Nobody got paid anything other than their expenses. And even after I moved back to Los Angeles and joined a law firm, I kept going back to teach for NITA. And eventually I became a board member and I chaired the board. And finally, in 2007, I said, okay, I'm turning over the reins to somebody else. But I just really thought that his taking a chance on me as a brand new lawyer was just, it just bolstered me in so many ways. And he was a wonderful mentor. Sadly passed away a number of years ago, but revered by all the people who knew him. Now, moving back to Los Angeles, that was a different experience. So in 1974, I moved to LA. I joined a law firm, and I was scheduled to be admitted to practice before the federal court in downtown Los Angeles, the Central District of California. So if you can visualize the courtroom, the Spring Street Courthouse was a mausoleum of a building with enormous courtrooms and just huge galleries. Our courtroom was full that morning because I was the youngest member of the team in my law firm representing a securities law defendant in a major securities case, a class action brought against the company. So at the beginning of the calendar, one of the young partners in the firm, standing next to me at the podium, begins to move my admission. And you would think that this is the kind of experience which is positive and pleasant. Well, the federal district judge before whom the case was pending was a fellow named Charles Carr. And with this courtroom full of lawyers and this young partner standing next to me starting to make a little speech about me, he just cuts him off. And he said, "Counsel," he looks at me, "Counsel, why did you pick me to get admitted before? Everybody knows how I feel about women practicing law." I got the barefoot and pregnant speech in front of the entire courtroom. So humiliating. And yet, I couldn't say anything. It might have affected my client had I stood up and said anything in my own defense. The young partner next to me just about crawled under the podium. He was so embarrassed. And later in the hall, a number of the lawyers in the case came up to me, said, "Louise, you know, that isn't the way all the federal judges here are, and we're so sorry that happened to you, and how horrible." And even his clerk came out and said, "I'm so sorry, I should have warned you." So it was common knowledge that Judge Carr was not welcoming to women in his court. And I just thought, well, I guess I cannot appear there again, because I certainly wasn't going to be able to do anything positive for my client if I did. That really pinned my ears back. But I went on. I became a partner in that firm, the first woman, and I practiced litigation in Los Angeles for about 25 years. Then, as you know, I turned my attention to being an arbitrator and a mediator as a solo practitioner, and I moved to Santa Barbara, about 100 miles from LA. So by then, I'd just about given up plans for going on the bench. I didn't have what I thought were the connections that you needed, and the political climate never seemed to be right. And after all, Santa Barbara is not a place of holding court. So there really wasn't much of a presence of the federal court in Santa Barbara, except there's a division of the bankruptcy court here. So I just thought, you know, bloom where you're planted, go ahead and, you know, just become a really good arbitrator and mediator. And that's what I intended to do. So life moves on, and it must have been, I don't know, 15 years later, maybe, I met Judge Ruggiero Aldisert. Now, Rugi Aldisert was a senior judge of the Third Circuit Court of Appeals. Now you'd say, well, how did you meet Rugi? Well, we were the only two members of the American Law Institute in Santa Barbara County. And the ALI publishes a book that shows where everybody lives. And Rugi looked in the book and he goes, well, here's somebody I don't know. So he got in touch with me and we became friends. Now, how does Rugi Aldisert from the Third Circuit, how does he end up in Santa Barbara, California?
I was going to ask that.
No sense. Well, turns out that in the 1980s, Rugi was the chief judge of the Third Circuit. And apparently, late in his tenure, he had a heart attack. And when he was convalescing from that heart attack, his doctor said to him, Judge, Pittsburgh, where he lived, was either too hot or too cold, and he should not stay there. So he decided he was going to move his chambers to California.
You can do that.
Right. I mean, why not? And so he decided to move to Goleta, which is a small town right next to Santa Barbara, and in an absolutely nondescript office building that also happened to house the city offices for the city of Goleta, he had his chambers. He had law clerks, he had a complete library, and every time there was oral argument in a case to which he was assigned, he did it by video conference. So get that. Here was Rugi Aldisert, and at the time I met him, he was almost 90 years old.
Wow.
Yeah, and so here he was, a senior judge on the Third Circuit, continuing to participate in oral argument and all the rest. So anyway, we meet each other, we became friendly, and I told him that in my heart of hearts, I had wanted to apply to be on the bench. And I told him that I had been considering trying to get a Superior Court appointment here in Santa Barbara. It's a small county. It's not a very big bench, and there wasn't a lot of turnover. But there was all of a sudden an open position for a part-time magistrate judge. Now, this is one of the really weird positions in the federal system. As we sit here today, Brian, I think there are 24 of us left in the entire United States. Whereas there used to be hundreds. It used to be really that the magistrate position was a part-time position. But gradually over the years, magistrate judges took hold and the position became a full-time position. Anyway, in a few places around the country, like Anchorage and Fargo and Santa Barbara, there are part-time magistrate judges still. So this job goes out over the internet. And one of my friends sends me an email and said, here's your job. This is perfect for you because you could be a part-time judge and you wouldn't have to leave Santa Barbara to be a federal judge. So Rugi says to me, I said, Rugi, you know, I've got my name in for the state court bench. And he goes, if you get a federal offer, he said, take the federal job.
I know there are justices in California, but U.S. magistrate judge sound.
It does. And so, even though it's not a place of holding court, there is this little slot for a part-time magistrate judge. So that was what ended up happening to me. I applied. Many of the people on the district court bench were people I had known for decades because they were my contemporaries. And I was chosen in late 2013, and then I had to pass the background check. And so in January of 2014, I took the bench. But here I was at a time when most people are planning their retirement. I take this new job.
Where was Justice Carr?
Yeah, really, he was long gone. Charlie Carr was long gone at that
Oh
time.
boy,
He
that is
probably really scratched his head wondering how did that happen, right?
absolutely.
Well, given who my mentor was, it wasn't any surprise that I'd be starting a new job in my 60s because Judge Aldiser at that point was still working and he was over 90. He is the one who administered the oath at my enrobing.
Hmm.
And I've always been grateful to him. He passed away not too long after that. He retired from the bench and then passed away. But he was very important, and it just shows you how important mentors are.
Absolutely, absolutely. Judge LaMothe, that's an incredible story and one that I didn't know before, and we have worked in different capacities before.
Yes.
Thank you so much
Yes.
for sharing. Moving from private practice to your ADR practice as a solo practitioner was also a bold move, especially as a female. A lot of times in ADR, it's been criticized as stale, pale, and male. And here you were as a female saying, you know what, enough of the firm, I can do it. Can you talk to the audience a little bit about that move and what went into that decision?
Yes, I'd be happy to, Brian. I think it was a convergence of a number of events. I had at that point a fairly young child who I thought would really benefit by having me around more, by having me have a more flexible schedule. And I think the one thing that I had come to realize over the years that I had practiced law as a litigator is your time is really not your own. Your clients need you, and they need you at very inopportune times. And judges set hearings without really much regard for your schedule. And I just needed more control over my life. And it really, really worked for me because since I was a mom, I could recognize when I was handling an arbitration what the lawyers appearing before me needed. And so if they said to me, you know, that's not really a convenient time for me, I didn't have to be hard-nosed about it unless it was going to somehow affect the progress of the case.
Right.
I could be a little looser. And I really think that making that shift helped me to be a better mom and to be a better spouse because I was around more. Before that, I had really lived my life on airplanes, as so many litigators do. So it was a really, really good transition. Now, it was hard because had we stayed in Los Angeles, a lot of people knew me. I had, as you note, a pretty high profile because I had been very active in the American Bar Association and to a lesser extent in the local bar as well. But in Santa Barbara, I had never practiced. Nobody knew me. It was a very slow start.
Yeah.
And a number of years, I couldn't get hired as a mediator for free.
Tell us how you did, though. Tell us how you did.
You know, eventually, what I did at first to get started was I went to Los Angeles a lot. One of the reasons we picked Santa Barbara was because it's 100 miles away and you could drive in and back the same day. And I did. And I still do when I need to. But I think also I did a lot of speaking. I did a lot of writing for the local bar magazine. And I just determined that I was going to work myself into a network. I met the women lawyers. I became active in the women's bar here. And they have been my staunchest supporters.
Absolutely. That is my next question. If you could talk a little bit about the importance of voluntary bar associations in your career development, what it's meant to you, and how it's allowed you to arrive as a U.S. magistrate judge.
Yes. I think what was really satisfying for me was the work I did first in the litigation section of the American Bar, and then second in the dispute resolution section. I've been an ABA member since my 20s. I really believe in the organization, and I think that it has been an enormous force for good during the years that I've been involved. And you know, we're not all of us involved at the same level all the time. When I was coming up through the litigation section, it was a major, major source of time for me. But in recent years, it hasn't been that important in the sense that it was something I did every single week. Now, pretty much, I'll do a program for the litigation section, or I'll make a speech for the dispute resolution section or something like that. It's not nearly as vigorous participation as it used to be. But for example, when I was chair of the litigation section, one of the things that bothered me was that I really thought that women advocates needed extra concentration. We needed a boost. And maybe because of the kind of experience I had had, I focused a lot on that. So I created a committee, which again, you can do when you're the chair, right? I created a committee and we called it the Woman Advocate. And we decided that we were going to put on a series of programs across the country. And it was like a 2-day program, as I remember, where we had women advocates talking about their experiences in court, in deposition, how to handle themselves around lawyers who were not respectful or decent to them, how to handle judges who challenged their qualifications, all of those kinds of things, because we all think that it's happening only to us, but that's not true. It happens to everybody who looks like us. So we put this program on. It was a blockbuster. Women came out of the woodwork and they felt so, as they expressed it, so supported for the first time that others out there were in the same position that they were. So we wrote a book and we published that. I think we have 3 editions of it now. Amazing. So, and we kept a committee within the litigation section of the ABA that continues to today. It's called the Woman Advocate. So, you know, you sort of plant your flag. When you're a bar leader, you get an opportunity to really chart the course of the Bar Association, but you make remarkable connections. And in the case of the American Bar Association, or the Federal Bar Association for that matter, because they're nationwide, you make connections all the way across the country. And it's fantastic. It's good for all of us. And it was very, very good for my career.
I certainly have. And Judge LaMothe, thank you so much for sharing that. It's not only that, you're active in the Chartered Institute of Arbitrators, and the list goes on, all sorts of voluntary bar associations still.
Yes.
Thank you so much for your service and example.
Well, you know what? It teaches you a lot too. In other words, we gain something from that. You know, for example, it's an interesting story. We had a branch of the Federal Bar Association for a while in Santa Barbara. But because the footprint of our court here was too small, we couldn't support it. And we finally had to let the local go and merge back into the Los Angeles chapter of the Federal Bar Association because it was so much more robust. But we're always looking for ways to extend the reach of the education provided and the camaraderie provided by these bar associations. It's really important.
Absolutely. And a source of affinity, like-minded individuals that can accelerate your career and help you start in a new community, even though those in the community might not know you yet, in the case of Santa
Yes.
Barbara.
Yeah.
Judge LaMothe, my last question for you, and what a fascinating story again. You were doing virtual, well, you were working, or you were friends with the Third Circuit Chief Judge who was doing video conferencing in Pittsburgh from Santa Barbara 20 years ago before COVID. That's a story. I'm
Isn't
not
it?
over that. But my last question for you is, in terms of diversity, equity, and inclusion, obviously, we still have a long way to go in terms of a woman's way to the federal bench. Could you speak a little bit about that, but also other underrepresented populations in the legal profession and how we get them involved in addition, and please speak to voluntary bar associations.
Yes, good idea. Well, it is difficult. You know, here in California, California Women Lawyers runs an annual program called So You Want to Be a Judge. And it is a model that I would recommend for any state and any judicial district, because I think part of the issue is that people have to put themselves forth. It never occurred to me that I would be seriously considered as a federal district judge in Los Angeles. I thought you needed to know the president. And so I never put my name forward, and I wasn't practicing at a law firm where there had been a history of a lot of judges. So, you know, some of the older law firms in Los Angeles, for many years, people had left the firm to go on the bench. That was not the case in the firm where I practiced. And so I didn't have that support within the law firm. And at the same time, back in those years, there wasn't organized support for women to come forward to seek jobs on the bench. So I would think that running a course or running a program like So You Want to Be a Judge is a great idea.
Yeah.
We did on our federal court several years ago, we ran such a class, and it was very, very well received. So I think that's one, is to tell women and other groups that historically have not been well represented, there is space for you. There is a place here. You just need to put yourself in front of us. You need to build your visibility. And a lot of times, people have come first to the federal bench by virtue of being magistrate judges. So for example, we've got a vacancy now on our federal magistrate judge ranks because one of our number has just retired. And I would encourage people to apply for the magistrate judge positions because they're wonderful and because you can be seen. And then I think you stand a very good chance of moving up if you want to. For me, the service for the court has been immensely gratifying. And I hope I can continue at least for a few more years. But you know, I handle a very, just a discreet little calendar up here in Santa Barbara that's a federal misdemeanor calendar based on the federal lands in this part of the district, the military bases like Vandenberg and so forth, and the National Forest and the Channel Islands. I have in that misdemeanor calendar so many unrepresented defendants. Lots of folks who don't have lawyers, and it might be their only contact with the justice system. I want it to be a good one.
Powerful, so powerful. Thank you so much, Judge LaMothe. Your career, your story is breathtaking, and it's a lot to chew on. I also note that as a U.S. Magistrate Court judge, your ADR skills are looked to within the U.S. court system, and I know that you've made inroads in terms of bringing to light the importance of settlement conferences, perhaps even more especially when we're dealing with pro se defendants and those that might not be otherwise adequately represented. You are a voice of justice, you are a voice of reason, and you are an American hero, frankly. Thank you so much for taking the time. Again, this has been the Federal Bar Association Centennial Celebration of the 19th Amendment, a woman's right to vote. I am privileged to be joined by the Honorable Louise LaMothe, U.S. Magistrate Judge for the Central District of California. Thank you again, Judge LaMothe.
Thank you so much, Brian.
Take care.